Is somebody messing with my stuff? What do you mean?
Why would you, yeah, why would it lock you out?
I don't know, it says, is currently locked out and may be logged onto. What are you talking about?
I have no clue what that is.
Is anybody even here at 10 to 8?
Probably not, let me see.
I mean, why do I have to reboot almost every day when I come in? Usually I just sign on. But this shit's making, it's making me do everything almost every day this week.
Yeah, no reason why it should lock you out. I'll take a look, let's check this thing up here.
Yeah, I mean, I don't even know, did I even shut her down?
You could try, shut her down.
Slide. Why
Wait a
would I
minute, wait.
slide it?
Hold on, let me see something. If you guys slide, let me see something.
I'm gonna poke you. Get the hell out of here.
Let's see.
I don't mess with you yesterday, you're all screwed up today.
Okay, now try it.
Yeah, that's, I've been hitting the same Maddie and May, 2025, bite me. There's that stupid thing.
Okay, put name in there.
Maddie and May.
Okay.
Maddie and May.
You see, okay.
Okay, now watch. There you go.
That's fine. That's fine. Sometimes it doesn't, it'll do that.
Yeah, it's giving me that 4 times, and I keep doing the same thing, and I can't, and it won't let me in.
Your username or password is incorrect.
I only have one username, and I only have one password, and it won't let me in.
See, it doesn't have. Gas lock is on, that's why. That's why I won't do it.
Oh, for God's sakes.
Now try.
That could do it, Bob.
Okay, now put it on there. Tell the gas
Oh,
lock.
my God.
No, it's
Now,
okay.
I get it.
No, let's see. Let's see. Let's
I
take a look.
get it.
I mean, the gas lock's not on.
No, I'm hitting it the same, whatever, and it won't take it. Oh, my God. What, we gotta do it 15 times?
I think I'm gonna kick back on to what it did before. So
Okay.
maybe it'll spin around and.
And now here we go again.
Kidding me? Skip. There we go.
All right, there it is, it picked it. Good God. You are gonna give me, that was not a fun, I was fine until that. Okay, this is not the one, that's not it, that's not, this is, I know what the Pop, I just know what the problem is now.
What's
It's,
that?
it's who we're starting with.
Oh.
I'm hoping she's going to be in an okay form of mind. Because she makes everybody miserable if she's not. Not sure why, but that's just kind of how that rolls. So there you go. Well, I'm glad you're here today, Bob.
good. There you are.
They usually make me sit in that chair.
That's all right. We'll do this for now. And if they say something, I'll tell them that I switch.
Good morning, Ashley.
Or
My name's
how are
Rachel
you?
Smith.
Hi.
How are you?
Good, how are you?
Good. Here, have a seat here.
I did put her in that chair. It's my
That's okay.
fault.
Have a seat. Chad told you I would be covering this morning, right?
Yes, ma'am.
You're still okay with that?
Yes.
Okay. So today we're gonna, hold on, stand up 1 second. One of our other attorneys must have been in that seat. There you go. All right. So today the plan is for you to plead guilty to an information, and then you will go to treatment this afternoon. Erin from our office will transport you, okay?
Okay.
So because we are pleading by way of information, that means your case did not go to the grand jury. So there were not people from Lake County who found probable cause. So we are waiving that right.
You want me to sign something?
So we will sign these later, but we're gonna go through them before we go into court so that, or before we start, so that everything goes smoothly on the record. So the first thing, you're gonna acknowledge that you have a right to have your case presented to the grand jury, but you're giving up that right because we entered an agreement with the prosecutor before that happened.
Okay.
Okay? The other thing is, because you're going straight to treatment, you're gonna be released on an owner cognizance bond.
Okay.
And what that means is that you don't have to give the court any money in order to leave. But if you were to not come back to court for sentencing, it would constitute a new offense that is a felony of the 4th degree,
Yeah.
okay? And so you're gonna sign this and acknowledge that you understand the
Okay.
importance of coming to court. This we will sign now. Are you able to witness this signature?
Ma'am, can you witness the signature? Can you witness the
Are
signature?
you able to witness a signature?
That's a great question.
Okay,
I don't actually know that.
Okay. If not, Bob will, it's no
Let me
big deal.
Let me ask the boss.
Okay.
I'll just send him a text real quick.
And then, so we will take care of that. Jim Matthews already signed this, so I am going to sign.
I have a doctor's excuse for PTSD. I didn't know.
For marijuana?
Yeah.
Okay,
Just so that just so that he knows, so that I don't mess up his bond. I don't wanna go into PSI and be, it's medical marijuana, so it's not like I'm dirty for like drugs or nothing. I just want the PSI people to be notified.
we will make sure of that, and we've got the letter from your
Doctor,
doctor
the doctor,
too.
yeah.
Okay,
Okay, that makes me probation more, and I don't have a drug and alcohol problem.
okay,
It helps me with my,
with your
Okay.
stressors?
yeah. It's nice meeting you.
You too.
I did almost 9 months on a case.
Yeah, I saw that you had
There's
a
a lot of
competency
treatment.
restoration, and that takes a lot of time. So you're
You
gonna
want me to
sign here, and you're acknowledging, the conditions of bond, and we'll address the exception for the use of marijuana with the judge.
Okay, thank you. You said with the exception of marijuana?
Yeah.
Okay. Just so when I go to, I gotta go to PSI, don't I? Is that what they call it?
Yes,
Okay, so, when I go to PSI, as long as they have that paper, I'll be fine. I just don't wanna go to PSI and be like, well, we're gonna lock you up. I wanna be able to do the bond and then show up to court and do it, you know what I mean?
yes.
I didn't want any problems.
That you already did the waiver. Oh, we don't have plea paperwork. I have everything but the plea paperwork. Hold on, I'll be right back.
Okay.
Unless it is in here. I'll be right back. Okay.
You were definitely right about the chair, huh?
Tells you.
I might know the boss to write it back. I wanna see about that.
out today.
You are?
Yeah, they let me out.
Okay, so
And I got my PTSD card approved,
just chill.
so I don't have no problems. Yeah.
Just chill.
Mhm. What a nice day. It's cold out though, huh? It's not really warm out. You know how they had a couple warm days? It's chilly out today.
Oh, yeah,
It's chilly.
you're really chilly. I
It's
think
just
I
now they let
left-
me out and it gets cold.
It said 40 degrees
Oh man. Did the weather just change like that recently?
in the last week. It went from 80 every day to like,
40.
yeah.
I'm glad they got a nice lawyer in here. The one guy, I couldn't understand what he was talking about. I understood what he was saying, but I didn't understand. I understand what she's saying. Yeah, but you go into PSI and you don't have a doctor's excuse or you don't have a judge's approval for medical marijuana, he can revoke your bond.
I don't know what PSI is, dear.
It's like a probation hearing. It's like probation questions.
The boss said we don't normally do that, but you might want to ask the bailiff, he could probably do it.
Okay.
Yeah.
So, this is the written plea of guilty, and we're gonna go through this. The judge is gonna go through it with you verbally on the record, and we go through it in writing as well, just to make sure everybody understands everything and there's no confusion as to what is happening, okay? So because you are entering a guilty plea, you're not gonna be going to trial. Because you're not going to trial, you don't need the rights that you would have in trial. But they're constitutional rights, so they're important, and the judge goes through them with you to make sure you know what you're giving up. And those rights include your right to have a trial, either to the judge or to a jury, your right to have an attorney represent you in that trial, and hold the state to its burden to prove you guilty beyond a reasonable doubt, to cross-examine the state's witnesses on your behalf, to bring in witnesses to testify favorably for you, and to use the court's subpoena power to bring them here to testify if they didn't want to come on their own, okay? Those are the things that you're giving up. You're also giving up your right to remain silent because you are making an admission of guilt.
Okay.
And because you're admitting your guilt, you are also giving up your right to appeal the court's guilty finding. By finding you guilty, after you've said you're guilty, the court is just agreeing with you, so we don't get to challenge that later on.
Okay.
But some rights to appeal that you never give up are your right to appeal a maximum sentence, which we don't expect to happen in your case. But if the judge were to send you to prison for the maximum period of time allowed under the law, you would be able to appeal that. You also never give up your right to appeal on the basis of ineffective assistance of counsel if you feel like I or Chad or haven't done our job, or prosecutorial misconduct if you feel like the prosecutor wasn't shooting straight. I don't see any of that in your
No,
case.
it was fine.
But you need to know that you have those rights. The judge is gonna ask you if you have had any drugs or alcohol in the last 24 to 48 hours. When he asks that question, he's not asking to check to see if you're doing something you shouldn't. He wants to make sure that you're making this decision with a clear mind.
Okay.
So the question does include any prescriptions. If you're taking any prescriptions, just let him know what they are, and he'll ask you a couple questions to make sure that you understand.
Okay.
Okay? So you are going to be pleading to a single count of breaking and entering. It's a felony of the 5th degree. The maximum prison term, if prison were to be imposed, is 12 months. There is no fine, no mandatory fine, but the court could impose a fine of up to $2,500. Prison is not mandatory in your case, and there's no presumption that the judge would send you to prison. In fact, for felonies of the 4th and 5th degree, there's a presumption that you will receive community control as a sentence. There are no other potential consequences like license suspensions or anything like that in your case. You are not pleading guilty to a felony of the 1st or 2nd degree, so you don't have to worry about the scary part about additional prison time. And because you're only pleading guilty to one count in one case, if the judge ran your sentences consecutively, it would be the same thing. It's a maximum of 12 months, a maximum fine of
Did he give me
25.
time served?
So you will get jail time, you will get credit for every day that you've spent in the jail, which is a
Does the
significant.
hospital count?
Yes.
Okay, that's good.
And then, we're getting to the portion of this that I call the parade of horribles.
Okay.
It's a series of ifs, and it all leads to worst possible scenario. We don't expect these things to happen with you, but you have to be aware that they are possibilities should something, go awry. Okay? So if the judge were to send you to prison, while you are in prison, you would be eligible for what's called good time. And that's by completing programs, you can reduce your sentence up 10 to 15%. And you would be eligible for both judicial release. Well, you would be eligible for judicial release. You could have up to 2 years of post-release control if you were sent to prison. Post-release control is kind of like probation after prison.
How much probation? Oh, they're not sentencing.
You're not
It's not
sentenced.
sentenced yet.
No, you're not going to be sentenced, and you won't be sentenced today.
The 14th of November?
Right, and then
Okay.
the judge can impose up to 5 years of community control as your sentence, okay? So if the judge sends you to prison, and if the prison system places you on post-release control, and then if you violate that post-release control, see how we're getting into these, there's a lot of ifs here. Then the violation of post-release control, they can send you back for, as penalty, up to 9 months each time, up to 50% of your total prison term. Now keep in mind, the maximum prison term you could get is 12 months, so the most time you would ever be able to do for post-release control violations is 6 months.
I've never known him not to give time served. He always gives time served.
That's you will get credit
Oh,
for,
yeah.
you will get credit for
Like I
those
did
days.
9 months on the F5, so like he has 3 months over my head.
Right,
Right,
exactly.
so if I get high, he'll probably try to send me to rehab or something, but I'm trying not to get high.
Yeah, we don't want you to get high, and that's why Erin's gonna take you to treatment later
Yeah.
today. Okay, so, now,
I understand.
okay, and then, so, still in that parade of horribles, if the judge sentences you to prison and the prison system places you on post-release control, and you violate that post-release control, and that violation itself is a new felony, the judge that sentences you on that felony can impose an additional prison term that would be consecutive of whatever time you have remaining on post-release control, or 1 year, whichever is greater, okay? So that ends the parade of horribles. Now we get to if you're granted community control, which there's a presumption for in your case. You will have conditions that you have to follow. If you violate those conditions, the judge can extend your community control, the time that you're on it. He can give you additional conditions that you have to, things that you have to complete. He can hold you in the jail, and he can impose local jail time as a sanction as well. You are a U.S. citizen, and even though you are, I have to let you know that pleading guilty to any felony offense can, and under the current administration, most certainly would result in immigration consequences. You don't face mandatory prison time, we talked about that. But if you ended up in prison at any point, you would be able to apply for judicial release.
Okay.
Okay?
Do you want me to sign?
Not yet, we'll sign it in open court with the prosecutor here.
Okay.
Do you have any questions about anything?
2 questions.
Yep,
You got the doctor's paper for the judge?
yes, I do.
Okay, that and, so I don't have any problems in the PSI. The other question is, how long do you think the paperwork will take to go through?
For you to be released today, it's usually a couple hours, so booking out is a process. And the time frame fluctuates based on what's going on at the jail and how the staffing is.
Okay,
All right?
thank you.
No problem.
It wasn't long, it was like, the time frame, cause they did 4.5 months in the jail, and then I did like less than 4 months in the hospital. So they broke it up in 2 different parts, so it wasn't a hard time, but the hardest part was when you first got locked up, and then the doctor went on vacation, so I had to wait. It was like walking on eggshells in the psych ward, cause if you say anything awkward, they'll say you're crazy, they won't let you out. And they've made me wait an extra month to get this group home that they're sending me to today.
Yeah.
So I don't want no problem with the group home, cause the doctor was like, make sure when you get to the group home that you don't, have any issues and stuff. That's why I keep telling her to make sure that card is okay so that we don't have a problem. But I paid the doctor, it's a private doctor, and it's a renewal of medical marijuana, so it's not like I'm trying to violate and haven't even got a chance to do it, you know what I mean? I don't wanna violate. I wanna come in here on the 14th and him sentence to me to what he's gonna sentence me to, and then he did probation with me one time in felony court. I've never done probation, and I ended up getting my own place and stuff. So hopefully I can get back on the right track by doing this. They don't have to give me no more than a year probation, but they still have to sentence me in 14. I don't want to go into PSI and have a problem because it's not normal. But I went to the psych ward and I do have PTSD.
What is PSI?
PSI is where you go into the probation department and they'll say like, where'd you grow up and who raised you and what's your drug of choice and stuff like that. And they'll try to say like if you're probationable or not, but I did a year before, but when I got off it was a mess. The day I got off I was a mess. I don't want to do that. I want to redeem myself. I want to do it over again. I want to do it appropriately. You know what I'm saying?
Smart.
I just want to do it over. When I get off probation, I want it to be okay. Like, just because I have the medical marijuana card, there's meetings in Willoughby and Madison, because I didn't know if I was going to either city, but if, let's say somebody's getting high in the house, because you don't know, you know what I'm saying, it's a group home or whatever. You just go to these meetings and it helps you where you don't get triggered to getting high or whatever. But I like how they have all the females today, because I've been in and out of this courtroom like for a week. This is my third court hearing in a week with John P. O'Donnell. Yeah.
Garbage. Makes you not think that, I don't care if it's modified or not.
Well, it's better than methamphetamines and cocaine and stuff like that. I get high. Yeah, that's what I'm saying. I get high, so I'm trying to prevent that from happening is what I'm trying to do. But hopefully everything goes smooth in court. They said you get a personal bond and you don't show back up to court, you get a felony 4.
Correct.
That's crazy.
Make sure you show it.
Yeah, he'll give you extra time. You get in trouble, you don't show back to court.
And the higher the felonies go, just like misdemeanors, the more time, the more you owe. Yeah.
Yeah, he wasn't sweet. I got 9 months on an F5. I was high and passed out in the house. I should have never went there though. You know what I'm saying? Should have never went over there.
But you know that.
And that's what happens when you're under the influence. You don't think clearly. You do stuff that you normally wouldn't do. So, this is a nice day. I wish it was just warmer out.
It's supposed to get a little warmer.
Supposed to get warmer out.
It's supposed to be like 70.
She's gonna come get me. We're gonna go get JoJo fries. Red Bulls.
Let me tell you the temperature.
Yeah, they would break. I know.
Right now it's 43,
It's cold.
and the high for today now looks like 64.
It's cold.
Yeah, I agree. It's not too bad though. I mean, at least it's not winter. Winter's the worst.
Yeah. She said that they have everybody at the group home around noon waiting for me or whatever. So it's only 8:30.
No, I wouldn't, listen, don't get one around the axle if it's not on time.
Yeah, I already thought that. I said I'd call.
Okay, we're good on the medical marijuana portion.
Okay, thank you.
Were you able to get the bailiff to sign?
He will, yeah.
Okay.
Good morning.
Good morning.
How are you?
Good, how are you?
I found out your guardian doesn't work on Fridays.
Oh, that's okay.
No, no, it's not. I'm actually kind of angry.
She wasn't here at all, huh? Well, we'll be okay. I thought I was gonna ask you about the PSI, but,
You'll be all right.
I'll be okay, cause he approved the medical marijuana.
But make sure she gets you back where you were last time with that apartment and all
Yeah,
that.
that's what I think they're doing,
Okay.
yeah. There was a letter inside his mail for you.
For me?
Yeah,
Did you? I
Yeah.
didn't get it.
yeah, it's John Piodon has it. It's in,
Why'd you send it? Did you send it to me or him?
I sent it to him,
Okay, then I'll get it.
yeah.
Sooner or later. Do you like Rachel?
Yeah, she's a nice day.
Rachel's very
It's a
nice.
beautiful, nice day.
Do you like her better than Malky?
No, he had to deal with.
I like
it's
her
okay.
better than Malky.
Yeah.
Hey Bob, can you witness the OR?
Yeah.
And I'll fill in the address once we confirm where Erin's taking her, because it's not noted in the file. And I can text Erin.
Did you guys set it up or did we set it up?
We did.
All right.
You can have her sign it now, I'll witness it afterwards.
Let's go ahead and sign.
Ashley, you remember the name of that place in Willoughby?
I think it's like North Coast.
No, you came from North Coast.
I'm not sure. I know that the Painesville House would know though. Like if you called the Painesville House, they would know.
Actually, do you have an address or anything that you've been, like, staying at, kind of, whatever?
Do you wanna
She's
put my
going to
dad's address?
treatment.
Yeah, I know.
You probably wanna put, Willoughby, Ohio. Willoughby, Ohio. Erin will know the address.
That's,
Yeah, Erin will know.
texting Erin now.
All rise.
Seated. Mr. Gagrich?
Thank you, Your Honor. Before you today on State versus Ashley Samaglio, file 25 CR 185. We're here today for an information. It's anticipated by the state of Ohio that the defendant will waive her right to have her case presented to the grand jury, and furthermore to enter a plea of guilty to a one-count information, one count of breaking and entering a felony of the 5th degree. The state of Ohio anticipates a community control sanction recommendation, which will be joint with the defense. Other than what's been spread upon the record, no threats or promises are made to this defendant to induce this plea. Thank you.
Okay. Ms. Smith?
Thank you, Your Honor. My understanding of what's to occur here this morning is consistent with that which was outlined by the state, and I do believe that Ms. Samaglio will be entering her guilty plea in a knowing, intelligent, and voluntary manner.
All right. Ashley, how old are you?
40 years old,
How far did you go through school?
some college.
Are you a U.S. citizen?
Yes, Your Honor.
Are you able to read, write, and understand the English language?
Yes,
Okay, now, are you taking prescription medication right now?
I take a metformin.
What?
I metformin.
What is it?
It's for diabetes. It's to
Any-
prevent
any- Any mental health medication right now?
And Invega, a mood stabilizer, but it's a shot.
Okay, when did you get that shot last?
Like 2 weeks, a week ago.
Any other mental health meds?
No,
All right, you understand what's going on here today?
yes, Your Honor.
All right. Did you get a copy of the charge that was filed, the information that was filed against you?
Yes,
Do you understand that you have the right to have the case presented to the grand jury for them to decide whether or not to charge you? Do you understand that?
Yes,
Did you discuss that right with Ms. Smith?
yes,
And are you going to waive that right?
yes.
Thank you. May I approach?
Uh-huh. All right, I'll accept the waiver of indictment now. Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm gonna ask you some questions. If you don't understand a question, or you want to talk to Ms. Smith some more, let me know and I'll give you more time. You understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes,
Are you waiving that right?
yes,
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt in a trial?
yes,
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
yes,
Are you waiving that right?
yes,
If those witnesses refuse to come to court, I'll issue an order that's called a subpoena to make them come and testify. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the right to testify at trial if you want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you decide not to testify at trial, nobody is allowed to comment on that decision. Do you understand that?
yes,
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
yes,
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford a copy of those transcripts, they'd be given to you free of charge. Do you understand that?
yes,
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
yes,
Do you have any questions about any of your rights?
no,
Do you still want to plead guilty to this charge?
I plead guilty.
Do you understand by pleading guilty, you're fully admitting your guilt to that charge?
Yes, Your Honor.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control.
Yes, Your Honor.
Now, breaking and entering is a felony of the 5th degree. It carries a maximum prison term of 12 months and a maximum fine of $2,500. Do you understand that?
Yes,
Do you understand that if a prison term is imposed, in this case, you might have to serve a period of post-release control under the parole authority for up to 2 years?
yes,
If you are put on post-release control, they'll give you conditions. If you violate their conditions, they could send you back to prison for up to 6 months at the maximum. Do you understand that?
yes,
If your violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
yes,
And if that happened, the most they could give you would be either 12 months or the time left under post-release control. Do you understand that?
yes,
Do you understand if a prison term is imposed, you are eligible for judicial release?
yes,
I could place you on community control for up to 5 years, but if you violate the conditions, I could send you to prison for 12 months. Do you understand that?
yes,
Has anybody promised you I would be lenient on you just because you're pleading guilty?
No,
Has anybody promised you what I will sentence you to in this case?
no,
Do you understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer?
yes,
Have you had enough time to talk with Ms. Smith before pleading guilty today?
yes,
Has she discussed everything about your case and answered all of your questions?
yes, thank you,
Are you satisfied with the advice she has given?
yes,
Have you been threatened or coerced in any way to plead guilty today?
no,
Are you freely, knowingly, and voluntarily entering your guilty plea?
yes,
Do you have any questions at this point?
no,
All right, Mr. Geiger, the case went to trial, what would the evidence show?
Thank you, Your Honor. The evidence would show that on February 3rd, 2025, the defendant, Painesville Police responded to 63 South State Street. Upon entering the building there, they found the defendant within the apartment that was boarded up. She had previously been issued a trespassing warning or
Letter?
notice. Yeah. And it was believed that she was using drugs within the building. Thank you.
Ms. Smith, anything to add to those facts?
Nothing to add to those facts, Your Honor.
Ashley, did you hear what Mr. Geiger said that the facts would show if the case went to a trial?
yes,
Are those facts true?
yes,
Or what is your plea to breaking and entering a felony 5? All
guilty,
right, Ms. Smith.
So this is the form that we went over before we came to court. It's just the original. I'm gonna sign here. I have in my hand the written plea of guilty, which I did have the opportunity to review with Ms. Smaglia before coming on the record. I answered all of her questions, and she indicated an understanding of the form.
May I approach?
I don't care, I got enough with her, so it doesn't matter. All right. Ashley, is this your signature on the written plea of guilty?
yes, Your Honor,
And did you sign it voluntarily?
yes,
And do you want me to accept your guilty plea?
yes, please,
I'll accept the guilty plea. The defendant was present. Ms. Smith advised of all of her rights, made a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequences of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary, will accept her plea of guilty and find her guilty of breaking and entering a felony 5. We refer this for an updated pre-sentence report. Sentencing will be November 14 at 10 a.m. I'm going to give you an own recognizance bond. What's the name of the place?
It's Willoughby Place, Your Honor.
Willoughby Place?
Willoughby Place.
All right, the condition is that you are to be transported and remain for treatment at Willoughby Place. If you leave Willoughby Place, then that violates the bond. Do you understand that?
yes, Your Honor,
Okay, and you gotta comply with whatever they're doing at that Willoughby Place. Do you understand that?
yes,
Any questions?
no, Your Honor,
All right. I don't know, they don't need much information for the PSR, so they may do it over the phone, I'm not sure.
Okay.
Get it done one way or another. Mr. Geigerich, anything else?
Nothing, Your Honor. Thank you.
Ms. Smith?
Your Honor, we would just like to make a record of the bond modification to allow Ms. Smaglia to use medical marijuana.
All right, we're not dealing with that right now,
Okay.
okay? We'll figure that out in the end, okay? All right, particularly because you're on that shot, and I don't know how that interacts with that shot. So let's address this when we come back in November.
So I'm just gonna put her to be transported immediately.
By the PD.
A
Bob, would you
by a
inform?
representative of the
Yes.
defender's office, yeah. questions?
Yeah, he said no to the medical.
For now,
Yeah.
I'll make a note for Chad to do some
What date was
research,
that? Or what?
as to how it
What's that?
interacts with the shot that you get. That's his only concern, because
Okay.
marijuana
I
can
didn't catch it either.
interact
I'll take a
with
look at
some
the doc.
medications.
Because I never write that down.
We have
Here we go.
Do you know how long this, you think the paperwork will take? She said you could do it over the phone, didn't you?
Well, that was the pre-sentence report, because they have pre-sentence reports on you from before, a lot of that information doesn't change. So, they may be able to do it over the phone or by video instead of you having to come back for probation.
Okay. All right,
You good?
yeah. Hopefully I'll be out of here by lunch. All right, thank you. Nice meeting you.
You ready to go?
Yep.
All
Bye,
right.
then. Bye, Nick.
All right, we'll see you.
Good luck, Ashley.
Be good there. Ashley, be good there.
Okay, thank you.
Yeah. Okay.
She's not whacked. She's not whacked right now. But she does want that medical marijuana, it seems like.
State of Ohio versus Desiree M. Headaway Harrell, case number 25 CR 706. The defendant is present today in court represented by attorney Jim Reardon. Were previously in court September 10th. The defendant pled guilty to an amended count 2, failure to comply with an order or signal of a police officer, a felony of the 4th degree. This matter was then referred for a pre-sentence report and we're scheduled for sentencing today. Thank you.
Mr. Reardon?
Your Honor, I received and reviewed the pre-sentence report. I have no additions, subtractions, corrections. As the court is aware, I've communicated that the difficulty in this case, the biggest difficulty in this case, is the defendant's penalty. It has to include a license suspension of at least 3 years and the inability to drive or gain any driving privileges. She has 2 young children. Per the report, I mean, my client has owned up to the offense. She certainly regrets it. She stated as much in the report and would certainly state to you that today. She understands what she faces. I believe, given her prior history and the facts of this case, that a community control sanction is appropriate, and certainly she'll do whatever the court orders and follow through. But I did want to express, and I've talked to my client, and she understands the terms of this are going to include no driving. She also understands that a condition of this is no substances, no alcohol, no marijuana, and she will comply. So that's all I have, Your Honor.
All right. Ms. Petaway Harrell, what do you want to tell me before I sentence you?
I just really regret that day. I know me not being able to drive it is a lot, will be a lot. It's just me, I have 2 boys. And that day that it happened, I actually had a driving privilege hearing like the next week, so I was literally on the path to getting driver's license. So it's just a lot. I'm trying, and with this punishment, it just seems like everything was all for nothing. But I do own up to my actions, and I do apologize, and I just want to move forward.
Okay, have a seat. Ms. Wood?
Thank you, Your Honor. On behalf of the state of Ohio, we are recommending a period of community control. While the state recognizes that this was not the worst form of the failure to comply offense, the defendant did not bring her vehicle to a stop after receiving a signal from the police officer. Thankfully, she did not cause any physical harm to herself or any other officers on the road or any other people traveling on the road at this time. She does have a history of juvenile adjudications and a slight criminal history, which is, I think, rare for defendants who do appear before you. But I think a period of community control with a substance abuse assessment and following all recommendations would be beneficial to her at this time. Thank you.
Okay.
And we would dismiss the remaining count in the indictment.
Thank you. All right, I've reviewed the pre-sentence report. Listen to the defendant, listen to Mr. Reardon, Ms. Wood. Place you on community control for a year, 3 days in jail with credit for 3, no drugs or alcohol, and you'll be subject to being screened. I'm going to have you get a drug and alcohol evaluation and follow the recommendations and pay the cost and supervision fees. Anything else, any other terms, Mr. Clement? Well, terms of community control. Do you understand the terms?
Yes.
You gotta stop smoking pot. It may be legal, which is a dumb idea, okay, but what are you gonna gain by smoking pot?
It's just a stress reliever. I just go through a lot.
All right, I understand you got two little kids, and the father passed away, okay, and it's difficult. You gotta work, and now you got this problem because you're gonna get your license suspended, but you gotta find another way to relieve stress other than smoking pot, okay? I'm gonna suspend your license for, it's a mandatory suspension for 3 years. It's gonna be retroactive to April 19th of this year. So you've got 2.5 years of
she need papers?
All rise.
Seated.
Thank you, Your Honor. We're here today in State of Ohio versus Wesley Bailey, case number 25 CR 0000766. Defendant is present in open court today with his counsel, James Reardon. Your Honor, we're here today for sentencing. The defendant was last before Your Honor on September 12th of 2025, where he pled guilty by way of information to one count of failure to notify change of telephone numbers or internet identifiers, registration of new telephone numbers or internet identifiers, felony of the 4th degree. At that time, a pre-sentence report and psychological evaluation were ordered. It's the state's understanding that those were completed and provided to the court, and that all parties are prepared to go to sentencing at this time. Thank you.
Thank you, Mr. Reardon.
Your Honor, that is accurate. I have received and I did review both the pre-sentence report and the evaluation done by the court's evaluator. Starting with the evaluation, the recommended course of action was based upon, apparently, Mr. Bailey has issues with anxiety disorder, potentially, I think it was cannabis and alcohol possible disorders, and that perhaps he had not been really examined or evaluated for those things in the past sufficiently. So the evaluator strongly recommended that the court order further evaluation for him and that he follow any and all recommendations for treatment so that he can be sufficiently rehabilitated and continue to abide by the court's orders going forward. I do believe in this.
Well, but he's demonstrated he's not interested in doing that, right?
Well,
Because
he
he's got
definitely-
an order that was in effect in the midst of a 25-year order that he didn't pay attention to. Why would he follow other orders?
Well, I believe that he will, and I believe that this.
History demonstrates he won't.
I understand the court's position on that, and he admits, and we admit that he violated the order. That's why we're here. And he did, but since that time, meaning since the violation, and we've been to court, and and he's doing what he needs to do to make sure it doesn't happen again. And the evaluator had a very in-depth interview with him and review of his history. And again, for whatever professional expertise that person has, is recommending that he do those things. And he will, if the court gives him the opportunity. Otherwise, as to the PSR and the community control, I believe he is amenable to community control. I believe he will follow your orders going forward. He will. He is not going to violate. He understands, he has his family, he has support, he has those who have stuck by him, they know what he's done, and they have decided to stick with him. He has 3 children, 3 minor children that he supports, that need him. His family needs him. The court has the ability to incarcerate him at any time. The court can incarcerate him. Today, the court can, yes, absolutely. You could send him away today. But you can also give him a chance to continue to do what's right for his family. And again, I understand the history aspect of it. Right, he did not. He did not. But this is a real strong further kick in the ass. It definitely is. And his family needs him, and he works, he does work, and he does support them. He does have good support. He has a really good chance of complying and rehabilitating and doing the right thing here. And the court can, the minute he screws it up, if he screws it up, the court can send him away. But I believe he at least deserves that chance in this circumstance. I believe he does. And the others around him believe he does too. And they know what happened. They know about all the activity, about the bogus phones, about the text messages. They know all about it. And he knows all about it. He knows it was wrong. He does.
Well, I don't know that he does, or he wouldn't. did you do it? You knew it was wrong all along, right? Why did you do it? You don't know. What's listed as an alias for you? Have a seat while we're talking. So tell me exactly what you did. didn't ask you to give me an assessment of your decision. I asked what you were doing. Have fun. What do you mean you were pretty much trying to have fun? What? Sexual encounters. Okay. And when did you start doing April when? April of 2024. When did you stop doing? Why did you stop doing? What? I stopped before they even knew. Well, how was it that you were able to stop? Threw the phones away. So you only started doing this in April. Is that right? So for 12 years you didn't do any of this. And then all of a sudden you started doing it. And I read this. Partial police narrative. It's in this pre-sentence report. And it says, engage in 61,859 text messages. What? I have no idea. You have no idea. So, so what you want me to believe is that you just all of a sudden started this in April of 24 and 61,659 text messages later, you all of a sudden just stopped because you wanted to stop. Is that right? Yes. Okay. I don't believe you. How many different devices did you have that weren't revealed, that were required to be revealed? How many different accounts did you create? Two, Your Honor. Just two. And you did this because you and your wife weren't getting along? Were you getting along with your parents during that time? So, Mr. Reardon, has this belief why do you, how old are you? Why do you need a babysitter? What? What do you mean it's more respect? I made that decision. Okay, so what exactly is the bad decision? Making the account. That you kept from her, right? Kept from your parents, you kept from your kids, you kept from everybody except yourself and the other females, right? So are you a deceitful person?
Thank you, Your Honor. We're in receipt of discovery and we'll be taking the state's offer under advisement at this time.
All right, we're gonna set this for a jury trial on January 5th at 8 o'clock. We'll have another hearing that'll be December 17th at 10 o'clock if a plea is gonna be entered. Anything else, Ms. Gold?
Your Honor, the defendant's sentence she's currently serving will be complete today, and she will be released on an OR bond.
Okay.
Would Your Honor be able to provide her with the own recognizance advisements?
I can't, but Bob can.
We'll do so.
Well, you mean to tell her if she doesn't show up?
Yes, Your Honor.
Okay, if you don't show up on the 17th of December for that hearing, then you're gonna get a new charge, a felony 4. Do you understand that? I'm gonna release you on your own recognizance, okay? Means you're gonna get out because your sentence is done on the other case today, okay? If you don't show up at a hearing, then that's a new criminal charge, a felony 4. Do you understand that?
I got a question. My question is, why couldn't I just pay bond?
I'm not making you pay any bond money. I'm just making you sign a paper saying you're gonna show up on December 17th or whenever your next hearing is. You don't have to pay any money. You just gotta guarantee me when you sign that paper, you're gonna show up at the next hearing. And what I'm telling you is if you don't show up at the next hearing, then you'll be charged with a new felony for not showing up. You understand that?
Uh-huh,
Any question about that?
okay. The 17th. Can I have more days than the 17th before I come back? Cause I've been gone for 2 months already,
We're gonna,
and my life is a shamble out there
Okay.
right now.
set it, 2 months from now is when that date is.
That's 2 months?
2 months from now,
Yeah,
2 months from
December, not
today.
November.
Oh, okay. But that's still gonna be right there at Christmas.
I know.
So can't you kick it back a little bit? Cause I got great grandkids and there's a lot going on. I'm
Okay.
finna be homeless. I got a lot going on. So can we kick that
No,
back a little bit
it's
further?
gonna be December 17th, but you're gonna get out today, okay? And you're
Uh-huh.
gonna be able to do everything you need to do in the next 2 months.
I understand that.
And
You
then
understand
what I
I'm being
want you to
honest.
do-
I'm
what I-
being honest.
I'm being honest too. What I want you to do is conduct yourself like you're supposed to and not get in any trouble.
I ain't gonna get in no trouble.
All right?
That ain't the question here. I ain't gonna get in no trouble. I already know I ain't gonna get in no trouble. But what I am asking you to do is work with me and let me come back after the Christmas weekend holidays to give me some time to be with these kids and be with
See,
everything I'm trying to do.
Here's how this generally works, okay?
Okay.
When you come back on the 17th, if you're gonna plead guilty on the 17th, okay, then I'm gonna give you another date in January, the end of January, to come back for your sentence. That's how I do it.
Okay.
So you're not gonna come here on the 17th.
And get locked up like
And get
happened to me
locked
that
up.
last time. Cause I'm telling you, I'm finna lose my house and everything else.
All right,
Cause
well
when
then-
I came that last time, they locked me up
All right.
and I'm finna lose housing and everything. Cause I wasn't expecting that. And I
Well, I'm
caught
just
3 buses to get down here.
I'm telling you how
out today? Do you want me to call your daughter and let her know?
Thanks.
She probably at work. I'm gonna have to catch the bus.
You right away, Bob?
Yeah,
Okay.
right away.
Alright, well, I
Remember,
will,
I caught them buses to come down here for them to lock me up and didn't even tell me they were gonna lock
honest with him, give him straight answers, don't try to beat around the bush, you know, when it comes to the treatment, let him know it's something you're definitely interested in. Do you think you need anything
That is unfortunately the
else
downside.
other than residential, like any sort of like aftercare, sober living, it will be a lot of work and a long process.
Yeah.
You gonna be up for it? Okay.
I'll leave you this.
I think if I just get my insurance thing worked out on my meds, then
Okay.
it would help. I need the mental health assessment. I have problems with signature, money-wise.
Have you gotten a mental health assessment? And speak with Mr. Spiesman. Today he would like to waive his final hearing, admit to the violation, and we are prepared to proceed with sentencing today as well. Thank you.
Is that what you want to do?
Yes, Your Honor.
What's your plea to the allegation?
Guilty, Your Honor.
I'll accept your guilty plea and find you guilty. Why are you back here?
I relapsed.
Why?
Found it.
Found it where?
In some old clothing, an old jacket.
Is that the story you want to stick with?
Yes, Your Honor. That's the truth.
No, it isn't. I've never seen a drug addict leave drugs laying around and not know where they are. The last one that was in here like that left it in his lunchbox from 6 months ago, or didn't leave it in there, used to keep it in there, and the sandwich must have rubbed off on the side of the cooler, and then he tested positive, okay? No drug addict leaves any drugs unused. So, you were just here in August, right?
Yes, Your Honor.
Why were you here in August?
JP violation.
You got kicked out.
Yeah.
Okay. Why are you communicating with Cindy Henley?
That's the only person I can get in contact with on my tablet.
What are you pissed off at Kim about?
I'm not. I just have no way to get a hold of her.
Okay, what are you pissed off at Kim about?
I'm not mad at her.
Okay. What am I supposed to do with you? You were here and got sentenced in July 2nd. Sent you to JTP, got kicked out of JTP because you were pissed off at something or somebody. And then I put you back on probation, you're back here again. 2 months, 2 violations. What am I supposed to do with you?
I'd really like to go to treatment.
Well, you went to treatment, you went to jail treatment. When you were here last time, I told you to go to IOP, you didn't go to IOP.
I almost had it started.
What do you mean you almost had it started?
Signature Health, I have other health things with. I have lab things. I owed $400. I was getting that waived and cleared, and so I could set up the assessment. They wouldn't set my assessment until I paid them
And
fees.
maybe you should go somewhere else other than Signature Health.
I do have that ready cleared.
Do have what ready?
I got the sliding scale and I got the Ryan White Foundation thing
Where?
at Signature Health.
See?
I do all my health stuff for the HIV stuff there too.
The what?
I have HIV, so I have to get my shots there. And I was just trying to keep it all in one spot.
They don't seem to do a very good job at that place.
I can go somewhere else then.
I mean, you got out of jail on this last one. Were you even in jail on the last violation?
Yeah.
Okay, so on August 19th, is when I told you to go to IOP, right?
Yes.
Okay. And they wouldn't let you in because you owed $400?
Yeah. For lab work.
I didn't know they did medical stuff at Signature Health. Kim, is that right?
That's correct, Judge, and that's why a lot of people will go to Signature Health because they can see doctors and nurses there, and they can handle
So, like, if I have a broken leg, I can go to Signature Health?
You can see someone.
Okay, maybe that's part of their problem. Maybe that's why they do a lousy job on the drug and alcohol stuff, and they don't really give a shit. You know, they get them in when they get them in, or do them over the computer and stuff like that. Is that, I was unaware of that until right now.
Yeah, they do.
Okay. All right, they're not doing you a very good service on your drug and alcohol, otherwise you wouldn't be here for the second time, after you were sentenced.
I'll go somewhere else then.
Your Honor, Mr. Spiesman has been put on a wait list for Lake House or Concord Pines pending what you decide to do with him today and pending admission. I know Aaron has been working with Mr. Spiesman to get him some sort of residential treatment in lieu of doing an outpatient treatment program.
Like what?
What do you
Where?
mean? Doing residential? Either Lake House or Concord Pines. That's where he's currently on the wait list for. I know Aaron, our office has a lot more resources, so if there's somewhere specific that you would like Mr. Spiesman to go.
I would like him to go not here. It's where I'd like you to go is not here. What's the wait time?
That I don't know, Your Honor. I don't believe the wait time is too long. I believe our clients have been able to get in fairly quickly, but I don't know the exact wait time. I can find out if needed.
How long has he been in, Kim?
He has been in 38 days, Your Honor.
All right, I'm gonna keep you on community control, 98 days, credit for 38. When a bed is available at Lake House or Concord, you're gonna go there, and the remainder of the days will be suspended. And you're gonna do everything I told you to do 2 times ago. Got it?
Yes, Your Honor.
I'm getting sick of seeing you. Ms. Randallson, anything else?
No, Your Honor.
All right, that's it.
was doing that the other day anyway, cause, the default was the one with the inlay in it,
Mhm.
and there wasn't anything on the screen.
Okay. Yeah, so that's all you gotta do. It's all set to go. Ugh.
Oh, see, Penelope is living her best life.
Yeah.
PSI,
Mhm.
drug and alcohol.
Yeah.
All rise.
See it. Mr. Rhoda?
Thank you, Judge. Before you this afternoon is case number 25 CR 812, captioned State of Ohio versus Stephen T. Pache. Judge, on September 12th of 2025, the Lake County Grand Jury indicted the defendant with 4 counts. The defendant is present today in court with counsel, Ms. Novotny, and it is the state's understanding that today he wishes to plead guilty to 2 of those 4 counts. Count 1, a lesser included offense of possession of cocaine, a felony of the 3rd degree in violation of ORC 2925.11. We arrive at the lesser included offense, the felony of the 3rd degree, based on the amount, adjusting the amount. And count 2, a charge of possession of a fentanyl-related compound, a felony of the 4th degree in violation of ORC 2925.11. Both of those charges carry forfeiture specifications, Judge. Should that plea be forthcoming, it's the state's further understanding that the defendant will be referred for a pre-sentence investigation and drug and alcohol evaluation. However, both the state and the defense have agreed to a joint recommendation for a prison sentence, but either party is free to ask for what amount they wish.
Mr. Novotny?
That's correct, Your Honor. Before coming into court today, I went over the written plea paperwork with Mr. Pache. He understands what is outcome of this hearing today. He would like to accept such offer that's provided and would like to change his plea.
All right, Mr. Pache, how old are you?
39.
How far did you go through school?
I graduated high school and went to vocational college for HVAC, heating and cooling.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 24 or 48 hours?
No.
Have you ever been diagnosed with or treated for a mental illness?
No.
Did you get a copy of the indictment?
Yes.
And it's been represented to me you're going to plead guilty to the lesser included offense in count 1, possession of cocaine, a felony 3, and the specification, and count 2, possession of a fentanyl-related compound, an F4, and that specification. Is that your understanding?
Yes.
Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Ms. Novotny some more, let me know and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yeah.
Are you waiving that right?
Yeah.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yeah.
After the witnesses are done testifying for the prosecutor, you have a constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yeah.
Are you waiving that right?
Yeah.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yep.
Are you waiving that right?
Yeah.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yeah.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yep.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yeah.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yeah.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yeah.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yeah.
Are you waiving that right?
Yeah.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
You still want to plead guilty to these charges?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yeah.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
The lesser included offense in count 1, possession of cocaine, is a felony 3, carries a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
Yes.
And that fine is mandatory. It's at least $5,000 up to $10,000. Do you understand that?
Yeah.
There's also a presumption of prison, that a prison sentence should be imposed on that count, and you must overcome that presumption, or a prison sentence must be imposed. Do you understand that?
Yes.
Count 2, possession of a fentanyl-related compound, is a felony 4 with an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yeah.
If you plead guilty to the forfeiture specifications on both counts, you're giving up those items listed. Do you understand that?
Yes.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 54 months and a maximum fine of $15,000. Do you understand that?
Yeah.
Are you on post-release control to the parole authority right now?
No.
Do you understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes.
You understand your felony conviction will prevent you from owning or possessing a firearm?
Yeah.
You understand that if a prison term is imposed, that you might have to serve a period of post-release control for up to 2 years under the parole authority.
Yeah.
If you violate the conditions of any post-release control conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yeah, I get it.
And if that were to occur, the maximum prison term for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
You understand if a prison term is imposed, you are eligible for judicial release.
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 54 months. You understand that?
Yeah.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
You understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer.
Yes.
Have you had enough time to talk with Ms. Novotny before pleading guilty today?
Yeah.
Has she discussed everything about your case and answered all of your questions?
Yeah.
Are you satisfied with the advice she has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
Mr. Rhoda, if the case went to trial, what would the evidence show?
Your Honor, had the state proceeded to trial in this matter, the state would have brought forth the following facts, and that was this, that in Eastlake, Lake County, Ohio, on May 24th of 2025, the Eastlake Police Department was called to a residence on 33822 Willowwick Drive. The call was placed by the defendant's friend or girlfriend at that time, out of concern for his medical condition. Defendant was found in the garage at that residence, sitting next to a dresser where the drugs that are at issue in count 1 and count 2 were located, and his driver's license was mixed among those baggies of drugs. Count 1 contains the charge of possession of cocaine, and count 2 relates to the fentanyl that was found
Second row.
in,
Second row.
in an open drawer, as well as the paraphernalia listed in the forfeiture specification with respect to in connection with the drugs. I'm sorry, Judge.
All right, Ms. Novotny, anything to add to the facts?
No, Your Honor.
Mr. Pache, did you hear what Ms. Narota said the facts would show if the case went to trial?
I did,
Are those facts true?
yeah.
All right, what is your plea to the lesser included offense in count 1, possession of cocaine, a felony 3?
Guilty?
What is your plea to count 2, possession of a fentanyl-related compound, a felony 4?
Guilty.
And what is your plea to both forfeiture specifications?
Guilty.
Ms. Novotny?
Prior to coming to court, Judge, that document was supplied to Ms. Novotny. It is the state's understanding she and her client did have an opportunity to review it before coming on the record.
Today's date is 10/17/25. And that's Your Honor, in open court, myself and Mr. Pache signed written plea paperwork and had the prosecutor witness.
Judge, I have signed on behalf of the state of Ohio.
Mr. Pache, is this your signature on this written plea of guilty?
Yes.
Did you sign it voluntarily?
Yeah.
And do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present with Ms. Novotny, advised of all of his rights. In a knowing, intelligent, voluntary waiver, he understands the nature of the charge and consequence of his guilty plea and the maximum penalty. Find to be knowing, intelligent, voluntary, will accept his plea of guilty and find him guilty of the lesser included offense in count 1, possession of cocaine, a felony 3, and the specification, and count 2, possession of a fentanyl-related compound, a felony 4. And that specification, I'll refer this for an updated pre-sentence report. Sentencing will be November 25 at 9:30, and the bond remains revoked. Anything else, Ms. Narota?
Nothing further, Judge.
Ms. Novotny?
No, Your Honor, thank you.
All right.
Okay, sure.
We'll work on getting the letter, you know.